Mark, you have to make that lower. I'm hearing that plus this.
Can you hear me?
She's talking to someone else.
Oh, okay.
Good afternoon and welcome to today's Protecting Artists and Dealers from Money Laundering in the Art Industry program. This discussion is sponsored by the Fine Arts Committee of the Entertainment Arts and Sports Law section of the New York State Bar Association. You may use the chat box to pose a question to the speakers. Feel free to unmute your audio and enable your cameras as we encourage you to engage in the Q&A session after the program. At this time, I will pass the floor over to the Easel Fine Arts Committee co-chairs, Judith Prouda and Carol Steinberg, who will introduce our presenters.
Thank you very much, everyone, and thank you, Charmin, and welcome, everyone. Carol and I are so delighted to see you, all of you, today, and we have a big group, so that's really wonderful. So this is a program on anti-money laundering. Carol will introduce Deborah, and then I'll introduce Tom, and then we'll turn it over to our speakers. Thank you so much for being here.
Yes, welcome everybody. It's great to see you. I'm very happy to introduce Deborah, and we actually met Deborah at the annual meeting where the Fine Arts Committee had a table to invite people to come and just talk to us. That is a really wonderful place. We met Deborah, so we encourage you all to join our committee, the Easel, and our Fine Arts Committee. Deborah is the founder of Herbeck Law, LLC, an arts and media law firm based in Manhattan. Deborah represents creative professionals, entrepreneurs, and artists in all areas and aspects of their work and acts as general counsel for Hyperallergic, the digital publication that has become required reading for those interested in fine art. Wonderful, wonderful publication online. The firm also provides risk management and anti-money laundering compliance services for galleries and dealers in the art industry. So happy to have you, Deborah.
Thank you.
And thank you, and welcome, Deborah, and welcome, Thomas. Thomas McDavid is head of financial crime at Sotheby's. He oversees their global anti-money laundering, anti-bribery and corruption, and sanctions programs, in addition to being the group money laundering reporting officer, with a focus on ensuring that the markets for artworks, cultural items, and luxury goods are not used for illicit purposes. He leads a team of specialists to guide day-to-day compliance operations and provide strategic guidance to senior leadership. He sides as the vice chair of the National Crime Agency's Art Market Working Group and the British Art Market Federation's Anti-Economic Crime Committee. He speaks regularly on financial crime in the art and luxury markets, and increasingly works with regulatory agencies to provide insight into the industry. So thank you, Deborah and Tom, for being here today. And I'm just going to turn the table over to you. So thank you.
Thank you. Can we have the first slide? And the second slide. So good afternoon. Thanks for joining us. Today, we're just going to give a broad overview of what the anti-money laundering regulations are and how they apply to the art industry. And no introductory slide in this area would be complete without a few acronyms. This is a very acronym-loaded area, and luckily they're mostly three-letter acronyms, and by the end of this presentation you are going to be pros at knocking around AML for art, anti-money laundering, PEP, which is a politically exposed person, KYC, which means know your customer. You probably have come across that. CTF, which I just learned from Thomas this morning, means counterterrorism financing. So we're going to go through all that sort of stuff. We're going to talk about sanctions because that actually is much more important in the United States right now than or applicable really in terms of actual regulations in the United States than the money laundering regulations. But we're going to talk about what AML regulations are and aren't in the US and abroad, particularly Europe. We're going to touch on best practices on how to comply with the regulations when they do apply to you, and how to minimize the risk of getting unwittingly drawn into an illegal art transaction, even if the regulations don't squarely apply to you. And finally, because so much of this has to do with, so much of the risk mitigation has to do with knowing your client and asking questions of your potential customer and buyer, there are huge privacy implications. And so we're going to talk about how you ensure the privacy of the information that you end up having to collect in the course of protecting your business. We can go to the next slide.
So we thought it might be helpful, given there are so many three-letter acronyms or TLAs in this space, to really start with a bit of an introduction and having a look at some of the key terms that we're going to be doing in more detail today. We also just want to add that Deborah and I have been working on this presentation to ensure that there's plenty of time for questions at the end. So if we do say anything, please do make a note of it, and we'll have a good chunk of time at the end for some questions. So where should we start in the introduction to financial crime? The big one, and the one that we often talk about the most, is money laundering. We're going to have a quick deep dive shortly into what money laundering looks like in the art market. But first of all, what is money laundering? Money laundering is a process whereby an individual, an entity, nefarious actors really, are trying to hide or disguise or obfuscate the source of funds or goods. So it could be money that individuals want to use to buy an artwork, a luxury item, for example, or it could be the item itself. And that's a really important thing to consider, that money laundering isn't just purely about cash. It can also mean a good, an item, an object. Terrorist financing. And this is the one that I think most of us need to be most concerned about. This is the one that has real implications should we get it wrong. And this is where terrorist organizations are trying to convert goods into money in order for them to fund their operations. This is something that's really relevant to the art market. At the tail end of 2023 and through 2024, there was a major terrorist financing money laundering investigation by the Treasury in the US Department of Justice, looking at an individual called Nazim Syed Ahmad, who is one of the most significant terrorist fundraisers for Hezbollah, and was using artworks being sold through galleries in New York, Chicago, and other US locations, and jewelry being shipped through the UAE, Hong Kong, Belgium, Switzerland, in order to fund these terrorist activities. It ultimately resulted with the seizure of a significant amount of property, some of which was held here in London at a major auction house's warehouse. Do please go and have a look at that case in more detail. There's some really good press about it, but it shows how important it is to know who our clients are to ensure that we're not allowing terrorist financing activities. The other side of this is proliferation financing, and it really goes hand in hand with terrorist financing. It's not something we see as much of in the art and luxury markets, but to be aware of. And that's where parties try to convert goods into money in order to fund the development or purchase of weapons. So these could be biological weapons, it could be weapons of mass destruction, for example, and that can be both directly or indirectly. One of the reasons I just wanted to pause on terrorist financing and proliferation financing is particularly when we're looking at jurisdictions in the Middle East, for example, it's a major focus for those regulators and under those laws. It's also those acronyms, so it's the AML, which is anti-money laundering, CTF, which is counter-terrorist financing, or CTPF, which is counter-terrorist and proliferation financing. Regulators want to see those acronyms or those words on your policies, on your risk assessments, but we'll look at that in some more detail later. And finally, as Deborah said, the big one in the States, and something we'll definitely look at more, is sanctions. And these are imposed by governments, and they can be against individuals, entities, or whole countries. And I think since 2023, we've seen a huge increase in the use of sanctions as a politically motivated tool. And it's something that I think we're all going to have to get used to as a new reality that we have to deal with. Sanctions carry strict liability, which means that, even if you didn't have any reason to not know that the party you were transacting with was an agent for a sanctioned party, you are still potentially criminally liable. The biggest enforcement action here recently is, if we look at 2020, there was a US Senate report, the Permanent Subcommittee on Investigations did a major investigation into the art market, looking at Sotheby's, Christie's, Bonhams, Phillips, and a private dealer in relation to sanction evasion through the art market. And that was specific to the Rottenbergs, who are close personal friends of Putin, and how they were using agents and shell companies in order to get around sanctions. This is seen as the warning to the art market. Any further failures will be significantly and severely punished. Next slide.
So we wanted to start with some of the basics of money laundering. Unfortunately, this slide got lost a bit in translation, but essentially it's the ABCs, or the 1, 2, 3 of money laundering, to make sure that everyone understands what we're talking about in this context. So the classic money laundering is the heist movies, where they break into a bank and they steal a precious gem. And then, of course, they can't take that stolen gem and do anything useful with it until they go to a fence. And the fence will give them pennies on the dollar to be able to and take the gem and dispose of it wherever they dispose of it. And the person who stole the gem ends up with cash that they can actually use at the grocery store. So it's basically the process of turning illegal or dirty money into clean or useful money that you can use in the regular market. And this typical sources of dirty money are, some of them are listed at the bottom half of the slide. The one that I want to draw your attention to is tax evasion. That is a crime. Well, technically it's a crime in the United States, but in other countries it's taken very, very seriously. And it's not uncommon for people that seem quite respectable, who might be purchasing art, to be tax dodging and using money that should have gone to their local treasuries to purchase art, and that could actually be a big problem for the seller. And the reason why taking action to make sure that you don't get caught up in these situations is important is because, again, going back to the heist analogy, the fence is a criminal. The fence is knowingly taking the stolen gem and giving the person who stole the gem money. And were the FBI to start investigating that theft, everyone's going to jail. So as the seller of art, you don't want to be finding yourself in the situation where you're the equivalent of the fence. And the only way, really, to protect yourself from that situation is to do a little bit of investigation yourself, a little bit of what we call due diligence, to minimize the risk that the source of funds is in fact dirty money that's being laundered through the purchase of the artwork. And a lot of the this can result in, for example, if somebody comes along and they are tax evading in a foreign country that cares about such things, and they use that money to buy your artwork, and then that crime gets investigated, and they find out that that person took the art. Now they're in trouble for tax dodging. That piece of art that they bought with the tax dodge monies will be seized. But in investigating that crime, your bank account as the seller of the art could also be frozen. This could be a complete mess for your business, even if you genuinely had no idea that this was a problematic source of funds. So, it's not always somebody coming in with cash in a paper bag, which we would hope would raise an eyebrow. It's cryptocurrency. It's people being a bit cagey. And so this is what you sort of have to be on the lookout for so that you don't unwittingly get drawn into an illegal transaction. Next slide, please.
So, as we've already touched on, the US has taken a slightly different approach to anti-money laundering regulations compared to the rest of the world. And as Deborah rightly pulled out, that quirk around tax evasion being a predicate offence or an offence that can lead to a money laundering offence is a key difference that we see. And whilst the US art market may be unregulated compared to other jurisdictions, it is always important to remember that if you are knowingly involved in money laundering, that is still a criminal offence in the US, as it is everywhere. And it's just something that always worth bearing in mind, that there are still relevant laws that you need to consider. But what about when we look at a global marketplace? And this is also really important when you might be undertaking occasional or one-off transactions within a jurisdiction. If you're a gallery or a dealer, and you've gone to an art fair, for example, you've come to London, you've gone to Paris, you've gone to somewhere in the Middle East, always be aware of the local requirements that will be that you need to adhere to. And I just wanted to run over a couple of the key ones here so you can get an idea of the variety that we're up against and also the changing nature of these. So we'll start with the UK. In the UK, the sale of artwork over 10,000 euros, not pounds, falls into a regulated transaction. What is the definition of an artwork? That is according to the UK VAT Act, which itself is not particularly clear. So what you often find is that you have a dealer coming from overseas, they've come to an art fair, they've sold an item that falls within the VAT Act over the value of 10,000 euros, which is about £8,500, around $10,000 now. And they haven't realized that what they've done is a regulated transaction. That means that their entire operation there is drawn into the regulated sector, requiring a huge additional amount of work required that we'll look at in more detail. If you do find yourself in the UK, I highly commend the British Art Market Federation's AML guidance. It is very clear, it is very well written, and it reflects very closely the requirements under the UK regulatory regime. That is available online as well. And it's something that is helpful to understand the regulated sector for the art market anywhere in the world. It really is one of the gold standards. We then get to the EU, and this is where it can get slightly confusing. Every member state of the EU, whilst they do have money laundering regulations in relation to the sale of art, they're all slightly different and they kick in at different places. So, for example, in Belgium, they might tell you, well, the regulations apply the moment you hang it on an artwork on the wall, whereas in France, it might be at the actual point of sale, for example. These regulations are also changing again in 2027, when the sixth anti-money laundering directive comes into effect. That's going to broaden the scope of the regulatory regime, fundamentally covering the sale of luxury goods over 10,000 euros as well, the sale of high-value cars, the sale of high-value yachts and private jets. So it's going to make a big impact into that regulated space. The Middle East, again, different jurisdictions have different regulations. The primary focus here currently is on those precious metals and stones, but this as well might be something we see changing. FATF, who are the Financial Action Task Force, one of the global regulatory oversight bodies for money laundering regulations, have recently changed the way that they evaluate countries' compliance with their set of recommendations, and that's going to gradually increase at looking at the art market. But even within the Middle East, you might have in the UAE, for example, two different sets of regimes. You have an onshore and offshore regime. So if you're in Abu Dhabi, the sale of precious metals and stones over 60,000 dirham is regulated. But if you're in the ADGM, the Abu Dhabi Global Market, which is the free zone within Abu Dhabi, the sale of any item over the value of $10,000 becomes regulated for AML purposes. So you need to be really careful about where you're operating, about which regime might kick in. Again, Asia, Singapore has a robust AML regime in relation to the sale of precious metals and stones. Hong Kong has recently enacted legislation that, particularly if you're a cash-based business, that kicks in very strongly. But one thing to just call out on Hong Kong is that they have this organized and serious crime ordinance, which is a very broad law that has been enacted that requires you to submit suspicious transaction report filings. We'll talk about those in some more detail later, but it is a quirk of the system there that Hong Kong historically has been seen as, you know, a similar market to the US. It's unregulated. There's relatively few regulations imposed. There is increasing attention being focused on the art market there. And there are also these really broad general laws that are often forgotten about, but we're seeing more action being taken and a greater interest taken by the authorities. One point just to add as well, something to consider is extraterritorial reach. Do you have a client located in a jurisdiction that by virtue of that, e.g. a client based in France, does that mean your entire transaction potentially could be covered by the French regulations? But really importantly, and as Deborah said earlier, sanctions. Sanctions have a huge extraterritorial reach, particularly if you're a US citizen, no US person, and that the US person, obviously an individual or an entity such as Sotheby's, which is headquartered in New York, US sanctions apply to our global business. They will travel, they'll follow you wherever you are. So because if an individual is sanctioned by the US, but you're doing a transaction in a country where they're not sanctioned, if you're a US citizen, that is still a sanctioned and forbidden transaction. There are also, you know, the local sanction regimes that apply as well. Make sure you don't get caught foul of this. They are very complex. And so it's always worth spending a bit of time just confirming where you're doing business, who you're doing business with. Next slide.
I just have a quick question for you, Tom, actually, on that particular point of extraterritorial reach. If I'm at an art gallery in Soho in New York, and I am selling a piece of art or wanting to sell a piece of art to a British person who walks in the door, is it clear whether or not I'm covered by the British regulations?
You wouldn't be covered by the British regulations unless that person was physically located in the UK whilst the transaction was happening. And this is an area of difficulty if you're an online platform, for example, and I do the transaction from London, I bought it online. There is an argument to say, was that transaction performed in the UK?
Got it. Thank you. That's an area that's always been unclear to me. So this slide we're going to go through very quickly because it is probably one of the most obsolete slides ever created in the history of webinar presentations. This is a brief synopsis of regulatory efforts in the United States to cover the art industry. We went through, well, actually what did happen about 10 years ago now, the Bank Secrecy Act was expanded to regulate antiquities, which basically means that most people know that when you go to a bank and you want to transfer money more than $10,000, it triggers a little bit more attention from the bank. So essentially the Bank Secrecy Act was going to be drawing in, or has drawn in, the antiquities market into the definition of a financial institution within the meaning of the Bank Secrecy Act. There was a lot of concern in the art industry that would be expanded to more broadly. Suffice it to say that never happened. There were efforts with something called the Enablers Act that went through a number of different contortions and died a slow death over many, many years when people like me were clamoring and saying, art industry people, get ready, the regulations are coming, and they never came. What we were left with, it's anything of note, is the Corporate Transparency Act. And even that has been completely eviscerated. The Corporate Transparency Act came into effect in January of 2024. And for the bulk of that calendar year, last year, businesses were running around worrying about filing beneficial ownership information with the Treasury Department. That was a new requirement where basically the government wanted to keep on file what individuals and entities were behind LLCs and corporations. It wasn't to be public record, but at least if those entities or corporations were found to be engaging in illegal activity, the government would know who was behind them and have a record of who to start going after to investigate those crimes. The domestic owners of corporations are now exempt from the requirement of identifying themselves. And it's only if the local company is foreign owned that there's any identity of beneficial ownership information required to be filed with FinCEN. Next slide, please. While this was all going on, when we actually thought we were going to have regulations, the US Treasury identified as targets for money laundering activity a little bit more than this, but the types of industries and areas that you see in the boxes in this slide. The US is the largest unregulated art market. And one concern is that since so much of the rest of the world is governed by anti-money laundering regulations, which can be a bit onerous, that money launderers will deliberately try to come to the US where people might be a little bit less used to asking questions. So but what's notable about this is that this list pretty much reflects what's known as an AMP or art market participant pursuant to the British regulations. And so there still is and still may in the future be some sense that there would be a regulatory regime in the United States that would mirror what's going on in the rest of the world. But if you fall into any of these categories, certainly when going to Europe, you need to know that you're most likely going to be falling under the regulatory regime of the local country that you're in. Next slide, please. And the next one. So getting into the practical side of this, one of the ways in which we protect against anti-money getting drawn into a money laundering situation or another illegal transaction is by establishing procedures and drawing into our business workflow the compliance. And I'm going to let Tom get into this a bit more in more depth since he's an actual person at a art company that sells art.
Thanks, Deborah. And I think this is where, some of the biggest conflicts occur between, the necessity for speed and agility in a transaction and actually the underlying regulatory requirements, particularly, as I said, when you're operating outside of the US. But for a whole plethora of reasons, these are things that you should build into your business now, and you should be advising any galleries that they should really be following a similar set of standards as these. That policies and procedures is key. Your policy is a document that really should outline your position on money laundering controls within your business. The procedures are much more operational. It's how do your teams actually perform something. So if you're operating in the regulated space as well, one thing that is really, really forefront and the front of all regulators' minds at the moment is a risk assessment. And this would be a business-wide risk assessment where you've looked at your business and assessed what potential risks do you have in relation to money laundering, but also in relation to counter-terrorist financing and proliferation financing. And that's a living document that should be updated regularly. And it allows you to demonstrate to a regulator, to law enforcement, to relevant and competent authorities, how you approach your money laundering regulations and those obligations. It's something, particularly in the UK, our regulator here, HMRC, is very, very keen on, but I've seen it in a number of jurisdictions recently. It's the first thing that regulators are asking for and looking at is a risk assessment of your business. Number two is something that probably causes the most pain globally, and it's certainly something that I have to deal with probably every hour whilst I'm at work, and that's identification of clients, client due diligence, CDD, another 3-letter acronym for you. Really, really important under all of our regulatory regimes, but also in the US under our OFAC sanction pillars. OFAC sanction compliance, very, very important. You need to know who you're transacting with. Client due diligence usually includes the collection of photographic state-issued ID, and in certain jurisdictions, it would also include proof of address as well. This is something that I think even 5 years ago caused a huge amount of furore from clients. How dare you ask me for this? We've been transacting for 20 years, for example. It's something now that is much more straightforward to ask for. The more people that ask for it, the easier it is. And it's also, just a really good defense to show, look, I've gone and I've tried to verify who my client is. And then the next level of that would be to run them through a database, 0.5 here. There are a huge number of databases available that you can run them through, and we'll have a look at some of the results you might see. Those PEPs, those politically exposed persons, sanction flags, law enforcement, various issues. For companies, entities, the really key part here is ultimate beneficial owner, or a UBO, a UBO. That is who is either owns or is in control of an entity. And that differentiation is something that occasionally is forgotten, that if you become aware that the shareholder on paper of an entity is actually acting as a proxy for a third party, you still need to ensure you know who is controlling that entity, who is the proxy acting on behalf of. In a similar way, one of the key points for sanction compliance is this agent principle issue. And that really came out in that 2020 US Senate report. Is your client an agent? E.g., are they acting on behalf of somebody else, or are they the principal, e.g., acting on their own behalf? This is something that should be, one of your first checklist questions to any prospective client, and it should definitely be included in your policies. If you have a sanctions issue and there's either an OFAC or a potential DOJ investigation, it's something that is a very clear defense to show that you had appropriate controls and procedures in place. And whilst, as I said, strict liability, it might not totally protect you, it shows that you were actively trying to look to see, were they an agent, were they a principal, who was our client, could we verify their identity? Source of funds, equally important, and something that increasingly law enforcement are requesting. A number of subpoenas have been issued over the last 18 months to various art market participants in relation to individuals buying or selling. What is their source of funds? This is particularly important, and we'll have a look at this in more detail, where there might be a red flag around the client, something like a high-risk jurisdiction, potentially information, as Deborah said earlier, in relation to tax evasion, depending on the jurisdiction, bribery and corruption. Part of identifying the source of funds of the client as well, it goes back to risk assessment and doing an individual client risk assessment. Are there high risk factors present that might require EDD, enhanced due diligence, which we would do on top of our CDD, our client due diligence. Maintaining records of transactions. These are hugely important. One thing you often see either from law enforcement, DOJ in the States, regulators, whoever, is can you reconstruct this transaction for me? What does that mean? Fundamentally, law enforcement come in and they say, we have found this item. We know it's connected to this crime. Can you reconstruct the transaction? Who was your seller? What were the circumstances? Where did they pay from? What documentation did you collect? What was the provenance of the item, for example? Making sure that you keep all of these and do have a look to check which jurisdiction you're in. But in the UK, for example, it's 5 years after a transaction or after the end of a business relationship. But in certain Middle Eastern jurisdictions, it can be 10 years or 7 years. So do just check to see how long you have to keep them. And the final one is suspicious activity reports, or in certain jurisdictions, suspicious transaction reports. This is particularly important in the UK and EU regimes, but also that Hong Kong example I used earlier, where you have information that comes to you that might give rise to suspicion. You are required to report that to the relevant financial FIU, the Financial Intelligence Unit for the jurisdiction. Suspicion is a really difficult one. What is suspicion? In the UK, there has been 2 examples of case law that have tried to define suspicion. It is more than a feeling of vague unease. What does that mean? I have absolutely no idea, and I look at this each and every day. Suspicion, fundamentally, if something doesn't feel right, if it feels like there's a problem, something's unusual, that for me is suspicion, and that might lead to a report having to be filed in the UK, for example, with the National Crime Agency. What are SARs? Why do we do them? Does it mean that we're, spying for the government, as one of my colleagues told me? No, it doesn't. It's actually a really good defense. You put your suspicious activity report in. You have then got a protection. You have said, look, this doesn't feel quite right. You can potentially, in certain jurisdictions, enter these in as a defense so that you can continue with the transaction after a certain period. Or you might have done a transaction and you put it in. It can remove the criminal liability. So it's something that's really good to do and just helps to protect the company that you work for and individuals involved in a transaction that doesn't feel quite right. Next slide, please.
So probably the most important 3-letter acronym is the KYC, know your customer, know your client, which is, again, a banking term that's applied to anti-money laundering regulations across the board. Essentially, it's implementing a compliance and a risk management policy in your art business is about identifying red flags, and meaning that when you see some of these sort of typical threshold behaviors, it doesn't mean the sale can't go through. It just means your ears should prick up a little bit and you should ask a few more questions. If someone's a bit cagey about presenting their identification, if the identification itself is a bit dodgy, not a passport or driver's license, and there's not a really good explanation why, if the person is a politically exposed person, which is something that Tom's going to get into, I think, in the very next slide. If the buyer is associated with a high-risk geographic location, there's countries such as Serbia and Ukraine that have been on lists forever. That basically, if someone's trying to initiate a transaction from those sorts of places, there's a risk they're a Russian oligarch or whatever. Or terrorist funding, etc. If the source of funds is not something you'd expect to see, a regular sort of wire transfer, etc. If it's cryptocurrency, if it's cash, these are all red flags that, again, not necessarily a bar to the transaction, but the sorts of things that are a threshold that should raise questions, raise a red flag, and make you ask a few more questions before deciding whether it's safe to proceed with the transaction. Next slide, please.
Thanks. And as Deborah said, when we see a red flag, and this is something that I train on constantly internally at work, a red flag does not kill a deal. It doesn't mean you can't do it. It prompts that enhanced due diligence. Ask more questions, have more documentation. Financial crime compliance is, and it's a great analogy, is just like a math problem. It doesn't always matter if you end up with the wrong answer, but if a regulator comes in, if law enforcement come in and you can show you're working and every step you've taken, all the information you had about a client that meant that you were happy to do that transaction, then that can be enough to defend you. You might not have information that law enforcement have that would have shown you that they could have been using art in order to launder money, in order to be a terrorist financer. So it's why it's always important to undertake that enhanced due diligence and make sure you keep that record of it. One of the key areas here are PEPs, politically exposed persons. Why are PEPs considered high risk? Quite frankly, it is because there is a greater chance and a greater risk often of the potential for bribery and corruption, particularly when we see politicians on this list, but also directors of state-owned entities is another red flag that we often see. The other one that isn't on this list but is worth considering is consul generals and ambassadors, particularly if they have diplomatic immunity, particularly if they are the consul general, for example, of a jurisdiction that is high risk and they don't have any obvious connection to that country. That's something I've seen a few times before. Why do you have this role? Have you given somebody money in order to obtain that diplomatic immunity status, for example? These are the sort of things I would look at. The other really important one, and again, high-risk jurisdictions and politically exposed persons, I often think go hand in hand together. When we think about someone like Isabel dos Santos, the daughter of the president of Angola, she is now sanctioned by the US, but was a PEP from a high-risk jurisdiction, and she was using her position there in order to strip the assets, the diamonds, everything out of that country and sell it for her own and her family's own gain. So again, think about the Marcos family from the Philippines, exactly the same example. Big, strong political families from high-risk jurisdictions can have significant red flags. Is it an automatic no? It isn't, but it is, where did your money come from? How did you come by this? Is there a legitimate source of wealth, a legitimate source of funds? Can we document this? Do you have a regulated bank account, for example, or are you using a bank account in an unrelated third country that's also high risk? These are where we might want to look at. And as the slide says, it's not just the individual themselves, it's somebody that's closely associated. That's why the Isabel dos Santos example, it was the daughter of the president, still a PEP, still closely connected. Next slide, please.
And the reason for the people affiliated with PEPs is that people who are on the PEP list tend to know that they're a PEP, and so they will sometimes try to evade identification by going through some, having their girlfriend make the transaction, etc. There's really no excuse for American businesses to not be making sure that they're not doing, there's lots of negatives here, but not be making sure that they're not doing business with sanctioned persons or companies. Those transactions are de facto criminal, not just illegal, criminal. It's very easy to run a check and see whether a person from a certain country, a person or a country that they're from, is on the sanctions list. It's a dynamic list, so you do need to check regularly, ideally contemporaneously with the transaction. But OFAC maintains a list of sanctioned countries that are sanctioned by the United States. And there's many other ways of finding this out. But it's absolutely critical to stay on top of this, especially in the art industry, which is becoming increasingly global. If it's identified that you participated in a sanctioned transaction, it doesn't matter if you knew or you didn't know. That's a crime. Next slide, please.
And I think this is probably, again, one of those questions that gets asked more often than any other within the industry. KYC versus confidentiality. The art market historically certainly was seen as a very cloak and dagger, very secretive world where nobody knew who was on the other side of a transaction. We can still maintain that confidentiality within the world of anti-money laundering compliance, sanction compliance. This is sensitive information, absolutely, but it is sensitive information that is required, particularly when you deal with a company such as Sotheby's. My role here within the compliance function, I am separate from the rest of the business. So information that often comes into my possession doesn't get circulated to anyone else in the business. You can therefore build up firewalls internally in order to safeguard information when there's particular sensitive information at hand. Or another alternative is in certain situations, if you're not a company with a compliance department, is to go to a trusted third party, somebody like Deborah, who you could have a reliance agreement on, and Deborah can perform that KYC check for you and on your behalf. That outsources that responsibility in order to undertake the KYC checks. One point on that, though, is it doesn't outsource the liability. If for whatever reason something goes wrong, the party that was meant to should have been undertaking the checks themselves would ultimately be held liable. It's why Sotheby's, for example, we don't tend to use reliance agreements. We conduct all of our due diligence in-house, so we can control the flow of that information. But for smaller art market participants, going to that trusted advisor is probably going to be one of your best options when there are additional confidentiality concerns. However, my experience is in probably 98% of transactions, the requesting of ID, for example, is totally fine and it goes through smoothly. It's now part of doing business in the same way that it is required to open a bank account or to do a whole host of other types of transaction. Thank you. I think, Deborah, do you have anything further to add?
No, I think the next slide says thank you, and is the end of the formal part of the presentation. We'd like to invite anyone that has any questions to let us know either via the chat or raise your hand, and if not, we can dive in a bit deeper to some of the areas that we didn't dig in deep enough.
What effect do you think the Trump administration is going to have on all of these policies, rules, regulations in the US, if any?
Probably eliminate, I mean, certainly defer any serious consideration that there had been of having regulations in the US is pretty much on ice. But again, as Thomas said, because the art market is global and there is extraterritorial reach of laws in Europe, etc., we need to be cognizant and take notice. And also the other major point is that because this is such a huge unregulated market and the rest of the world is actually gearing up to protect itself, we could become a real lightning rod for criminals who are looking for a place to transact business without so many questions being asked.
I also think one of the other key considerations here is, again, make sure you're doing your KYC, because you could find that under the Trump administration, there's going to be a particular focus on a type of corruption. We've already seen drug trafficking, for example, be a major focus of the administration. What you could then find is a huge number of subpoenas being sent out to the art market where there is a known kingpin or something like that, that again require you to hand over all of this information. If you don't have it and you've done something that could be considered illegal or nefarious, you don't have a strong position. I think that's potentially the other area that we could see a change in approach.
I see Maria has her hand up.
Oh, yes. Thank you for your presentation. First of all, I've been a practicing attorney. As part of my track record, I've been dealing with the IML for high net worth and ultra high net worth individuals for the asset management company. Now, our KYC and AML is obviously very similar. What I'm struggling to understand with respect to Sotheby's or Christie's specifically are where do you draw the line between your client showing your source of funds and tracking down if at 2 or 3 transactions down the line there might be a proliferation of terrorist activity or whatever other restricted kind of transaction, or it could be the source of those illegal activities could be used to then go and buy the art again through a number of transactions. So where do you draw the line?
So that would then go back to ultimately our client risk assessment, and we would carry out our client risk assessment And if we, once having carried that out, if there were high risk factors, for example, an association to a jurisdiction that is known to have links with proliferation financing, so take Lebanon as the example from the recent Nazim Syed Ahmad case, if you would see that, that would be a red flag. If you then say, right, you're not a known collector, so what are you doing here? I think that's probably the other differentiator between a Sotheby's, a Christie's, and an asset management company, is that, you know, our top 100 clients make up the majority of our transactions, and we know them incredibly well. If you have an individual that walks in off the street suddenly wanting to spend $50 million, that's an instant red flag. Even if you have a client who was a relatively low level transactor and then, you know, goes through the roof, that's another red flag that we train on, that we would look at. And so that's really how, if we then saw that, that's when we would dig in and say, right, we need to do additional enhanced due diligence. If we couldn't get comfortable, we'd then take a decision, right, we're going to stop transactions here, because again, it's at our discretion whether we do a transaction, or is there enough of a cause to then outsource? We do most of our EDD in-house, but in rare cases, we would go to a Kroll, a K2, an Ardello, for example, in order to get a more detailed report, in a hope that we would have clarity.
Got it. Thank you so much.
So I see we have a question from Mika Conway. Does filing a suspicious activity report involve the possibility of hearing back from the applicable regulator that a transaction can or cannot go forward, or is it just a matter of documenting due diligence that may be useful later, if ever? Actually, neither. If you've done some digging to the point that you feel compelled to or are obligated to, if you're covered by a regulation that makes you a reportable party, that you're filing a suspicious activity report, you really shouldn't go through with that transaction. That clearly has risen to the level of a transaction that is suspicious enough to report to the authorities. So yes, you can document that you've done the due diligence and should, but the regulator will, if they look into it, will be looking into whether there's a crime to be prosecuted. They won't be, they will probably assume that you didn't go through with the transaction. It wouldn't be for them to tell you whether it's okay or not.
I think there's one, the UK has a very specific type of SAR called a DAML, which is a defense against anti-money laundering, or defense against money laundering even. And that is one where you can put in an activity that you have a suspicion. If you would have information that would say this is money laundering, absolutely you can't do it. If you have a suspicion, you can put in a DAML, and there's a 10-day moratorium period where in the UK, the National Crime Agency, the FIU, can come back to you and ask additional questions, and they can give you consent. That's not to say that they've approved the transaction, but they've given you a criminal defense. That also means, though, that the transaction could be unwound, there could be other prosecutions, etc. But that moratorium, that if it gets denied, that moratorium period could also continue. But that's a very rare type of SAR, and Deborah's entirely correct. And the position should be, if you've got to a point that a SAR is required, you shouldn't really be doing that transaction.
We have a great question from Jerry Fletcher, very practical and comes up all the time. How do you identify the source of funds? What documents, types of documents do you ask for? How can you tell that they are trustworthy? This comes up time and time again. So the baseline documents are clearly, ID. If red flags have arisen in the course of your sort of baseline investigation, and you have to start digging into source of funds, which you sometimes have to do anyway, depending on the regulatory regime you're working under, you ask for things like for example, somebody says that the funds came from selling their house. Well, you would need a bank letter or proof that that transaction had taken place and what kind of profit you made from that transaction. So this is why the privacy becomes very important. You really, once you get to the enhanced due diligence level, you are asking for quite personal information. In terms of how you can tell if they're trustworthy, there's a lot of software these days that can test right away whether an ID is valid, for example. And I guess there's Art Sales Vault is a software company that some colleagues and I developed, where basically the customer can put in their ID, and the software will basically say, yes, this is a valid ID, and then they'll do a search for that person identified in that ID, and see whether they're on the sanction list, and see whether they're a PEP, and sort of spit out a report, giving you information that might raise a red flag or not, or sort of say, go ahead, this looks fine. I'm sure that Thomas has something to add to that answer.
Yeah, I think it's a great question. Automated technology, particularly in the last few years, has got so much better. I've seen quite a few different documents. Some of them are clearly fake. And something that, just to flag here as well, is if somebody gives you a forged document with the intention of trying to deceive you, that itself is a criminal offence and would be a reportable in many jurisdictions. So just something to bear in mind. Again, it can be as simple as, can you provide your pay slips? That is very sensitive information. In countries such as Spain, they have very strict regulations regarding this, and the sale of art is treated like the sale of property in the UK, and you need to show wills for inheritance. You need to show every bit of detail. You can really show anything to demonstrate that the amount of money a client wants to purchase, let's take it on that side, they have that, and that it came from a legitimate source. There are normally probably 3 or 4 answers you're going to get. One is salary, one is investments, one is inheritance, and the other is either a gift or potentially a fifth of the sale of a house. You can get a simple declaration, and that might come through a third-party attorney as well. I think the key here is, if something obviously doesn't look right, that's when you stop. But there is always that feeling that, to what extent, and it runs into Maria's question as well, where do you draw the line? If you've done your checks, if you've done everything you reasonably can to confirm something, that might be as far as you can go. It then comes down to that judgment of, do you trust it? Do you accept it? Would you proceed with the transaction?
And if you've done all that, even if it ends up being an illegal transaction, you're covered. You have a defense.
Yeah.
You've done your best.
Yeah, I have a related question, actually, very practical. What about a small gallery? I mean, they may not have the resources to do all of this due diligence prior to a sale.
This is, probably one of the biggest questions of the moment within the art market. And it's something that in the UK, the British Art Market Federation is very vocal about, trying to lobby our government here, because it is a huge burden on small galleries. A small gallery has got to look after their finances, they've got to look after their taxes, they've got to look after shipping, sourcing. Then to add this is another fairly alien layer, quite frankly, that isn't, natural. My response to that is, there's a few options. You can, one, as I said, have a Deborah on hand that you can call for advice and to help you out, particularly on maybe a bigger transaction that you do less infrequently. There are a few providers that do sort of fairly generic art market AML services and providers, which is fairly helpful and can be right for smaller galleries. Or the old-fashioned way is you read through something like the British Art Market Federation guidance, and you get an idea of it yourself, and you build your own program, and you've just got to go and learn it, which I know isn't a great answer, but it is one option that you can do, and it's probably the most cost-effective.
Thank you so much. This has been really very informative, and I think Carol and I thank you for joining us this afternoon, and thank the audience. Thank you so much. This session was recorded, so we will be posting it, and you'll be able to listen to it again if you have any questions about what was said. Thank you so much.
Thank you
And
so much.
yeah.
It was really great.
it was a terrific,
Clear, thorough, wonderful. Great
Yeah.
questions too.
yeah, terrific program, and so much for your excellent questions to the audience. So I think that concludes the program. That's it. Thank you.
Thank you.
And
Thanks very much, everyone.
Thank you.
have a good rest of
care.
your day. Thank you.
Out of here.